Hello! The aim of this video is to try and give students who are currently studying family law a quick update on some of the latest developments in this area. Most of you will know by this point that I have a whole series of videos that cover all of the subjects that will come up on a family law course, and that is available to purchase through my website at uklawweekly.com or through Gumroad, and I'll make sure to put a link in the description below. But as I say, the point of this is to try and make sure that the people who have bought that course or are just studying family law in general are up to date with the latest cases and potential statutes that are going to be coming through over the next sort of 12 months or so that they can include those points in, say, a piece of coursework or in the exam, so it at least makes it look like they're keeping up with those latest trends and developments. So the first case that we're going to be looking at is the Crown on the application of TT and the Registrar General for England and Wales. And this case centres around someone called Freddie McConnell, originally registered in the courts as TT, but those reporting restrictions have now been lifted because Freddie McConnell is going to be the centrepiece of a new documentary that is coming out about his struggle. That's called Seahorse. I believe it's in film festivals at the moment, but is probably going to be broadcast on the BBC later on this year in 2019. Freddie McConnell was born as a woman, but is a transgender man who actually conceived a child not long after legally being recognised as a man in the eyes of the law. Now, those of you who have actually watched my course or have perhaps studied family law in the past will know that the legal definition of a mother is actually very simple, and it's simply the person who actually gives birth to the child. And this meant that although Freddie McConnell is legally recognised as a man, he was also legally recognised as the mother of the child. And mother is obviously a very gendered term, and so McConnell wanted to be recognised as either the father of the child, which would probably be more appropriate, or even simply as a parent, which would cover him as a man, rather than the term mother, which is obviously normally associated with someone who is female. Now, this case actually failed at the High Court level. It's likely going to be progressing to the Court of Appeal, and it wouldn't surprise me if it's made its way all the way to the Supreme Court. Even though it failed in the High Court, the judge was very sympathetic to McConnell's case, and in fact said that there were a number of issues that were raised about the fairness of the law, especially its relationship with Article 8 of the European Convention on Human Rights, which is to do with the right to private and family life. So definitely one to be keeping an eye on there. There are also a couple of bills that are currently working their way through Parliament. The one that is probably more likely to get passed in the near future and one to definitely keep an eye on is the Domestic Abuse Bill. This was a centrepiece of Theresa May's government when she was in power. She's no longer the Prime Minister, but it's likely that her bill is going to move forward and could receive royal assent. One of the key issues at the moment, at the time of recording, is whether Parliament is going to be dissolved at some point by Boris Johnson, in which case the Domestic Abuse Bill might not make its way through and could be significantly delayed. However, it's a really important piece of legislation that is going to attract widespread support from across both sides of the House of Commons, and it would do a number of things. So first of all, it would provide a statutory definition of domestic abuse that includes non-physical abuse, so things like psychological abuse, and financial abuse as well. It would give new powers as well, such as a domestic abuse protection notice or orders, which would allow for earlier intervention by the authorities, such as the police, in cases of domestic abuse. Beyond that, it would place a legal duty on councils to provide safe housing for those fleeing domestic abuse, and also potentially a safer environment in courts when it comes to evidence and witness testimony. This is a real issue at the moment because a lot of people are afraid to come forward in cases of domestic abuse, because if the case actually makes to court, it can be obviously very intimidating for someone to be cross-examined by their abuser. So definitely something to keep an eye on, and this could be a real landmark piece of legislation. Another landmark piece of legislation that's probably a little bit further down the line is the Divorce, Dissolution and Separation Bill. And the idea here is that you can have a non-contested divorce. At the moment, when you have a divorce, there is a single ground for divorce, but then one of the 5 facts of divorce has to actually be produced under the Matrimonial Causes Act 1972. And this can lead to particular cases where people are denied divorces because the divorce is contested and the irretrievable breakdown of marriage is not satisfied. On the other hand, we can now potentially have a new fact of divorce, which would be a statement of irretrievable breakdown, and that in itself would be conclusive evidence that could not be contested. So you would avoid a number of those recent cases where the wife or the husband is unable to get a divorce. There would also be an option for a joint application, which could potentially speed things up. And we would also be introducing new terminology. So rather than some of those old-fashioned phrases like a decree nisi or a decree absolute, you would have a conditional order and a final order, and instead of a petitioner, you would have an applicant instead. So a number of things going on in that bill, probably a little bit further down the line than the domestic abuse bill, but also equally important. The final case that we're going to be looking at is the case of Crowther and Crowther, and the question really here is how far a judge should be allowed to go in helping a litigant in person. Now, one of the things that has dominated the case law in family law over the past sort of 5 or 6 years is the Legal Aid Sentencing and Punishment of Offenders Act from 2012, which really did a lot to cut legal aid in this particular area. This can often lead to situations such as in Crowther and Crowther, where the one of the parties has access to legal advice and is represented by a barrister, while the other person, who maybe is of lesser means, is not able to get the same level of help, and so they might be often representing themselves. That can cause a real issue, and it's a real imbalance between the parties when you are trying to achieve justice. In a lot of cases, the judge will try and intervene and at least do their best to help one of the parties, but this is obviously going to be criticised in some quarters because the judge, that's not really the role of the judge, and it's questionable whether they should actually be doing that. That was the question in Crowther and Crowther, and it's quite an interesting case that you should maybe go ahead and go and read. But essentially, the judge was kind of reprimanded in the upper courts for going too far in helping a litigant in person. So quite a controversial particular case there, and one that's probably we're going to be seeing more of rather than less of in the upcoming years as the effects of legal aid take hold. Well, thank you very much for tuning into this update. As I said, you can purchase the family law course on my website at uklawweekly.com, or I'll put a direct link to the Gumroad site in the description below. I hope you enjoy studying family law if that's what you're doing this year, and I'll come back with further updates next year as well. Thank you very much for listening. Bye!